Justice and Human Rights. Pursuant to the order of reference of November 18, 2025, the committee is meeting to continue its study of Bill C-14, an act to amend the Criminal Code, the Youth Criminal Justice Act, and the National Defense Act, bail and sentencing. Today's meeting is taking place in a hybrid format. Pursuant to the standing orders, members are attending in person in the room and remotely using the Zoom application. I'd like to confirm that sound tests were made successfully. Before we continue, I would ask all in-person participants to consult the guidelines written on the cards on the table. These measures are in place to help prevent audio and feedback incidents and to protect the health and safety of all participants, including and especially the interpreters. You will also notice a QR code on the card which links to a short awareness video. I'd like to take a few moments for the benefit of witnesses and members. Please wait until I recognize you by name before speaking. For those participating by video conference, click on the microphone icon to activate your mic, and please mute yourself when you are not speaking. For those on Zoom, at the bottom of your screen, you can select the appropriate channel for interpretation, either Floor, English, or French. For those in the room, you can use the earpiece and select the desired channel. Reminder that all comments should be addressed through the chair. For members on Zoom, if you wish to speak, please raise your hand. For members on Zoom, please use the raise hand function. The clerk and I will manage the speaking order as best we can. We appreciate your patience. And this morning, we have two panels of witnesses. In the first hour, I would like to welcome our witnesses. We have from the Association of Manitoba Municipalities here in person, Catherine Valentino, the president. Thank you for being here. Online, we have from the Canadian Urban Transit Association, Michael Atlas is the honorary counsel, and also with us this morning from the National Police Federation's President Brian Sauvé. So welcome to the witnesses. Pleased you're being here. We're pleased you're here. This is a very important piece of legislation, which I know is the opinion of everybody in this room. And I should point out it's also the opinion of all of the premiers from across the country who on Friday issued a joint statement encouraging us to pass Bill C-14 expeditiously, to use their words. So I'm glad everybody is enthused about it. And in that vein, I just want to let the members know that on Wednesday we will be starting at 3:30, not 4:30, and we have resources for more than we should need, but until 1 in the morning, I'm told. Mr. Brock?
Mr. Chair, that could be problematic. I think we have 4 votes after QP.
It's subject to votes, of course.
Right. Okay.
Yeah, I mean, the reason we were starting at 4:30 regularly was because of votes, so it may end up being that case. At 3:30, as soon as the votes are done, put it that way.
Will there be witnesses to start, or?
And we have 2 hours of witnesses to start Wednesday, and then we'll go right into clause by clause. So on that note, I will open the floor to the witnesses who have 5 minutes each for their opening statements, up to 5 minutes each for their opening statements. So I'll just start on my left, Mr. Sauvé.
Good morning, Chair and members of the committee. My name is Brian Sauvé. I'm a sergeant with the RCMP, but also president of the National Police Federation, the union representing nearly 20,000 members of the RCMP across Canada and internationally. Thank you for the opportunity to appear today to discuss Bill C-14. Our members see every day the impact that a small number of high-risk repeat violent offenders have on community safety. They also see the strain placed on victims, witnesses, and frontline police officers when those individuals are repeatedly released, breach their conditions, and quickly return to the streets. Bill C-14 is a meaningful step forward addressing this reality. The NPF supports the bill's clarification that public safety must be explicitly weighed in bail decisions. This aligns the law more closely with what police encounter on the ground. Individuals with lengthy criminal histories, repeated breaches of court orders, and escalating patterns of violence too often cycle through the system under conditions that prove ineffective or unenforceable. We also support the targeted expansion of reverse onus provisions for serious violent and weapons-related offenses. In clearly high-risk situations, it is reasonable and appropriate to require the accused to demonstrate why their release would not endanger the public. This change promotes greater consistency across the country and better reflects real-world risk. Additional measures in the bill, such as mandatory no weapons conditions for organized crime offenses and direction to consider whether an offense was random and unprovoked, further strengthen the public safety lens applied at bail. However, legislative reform on its own is not enough. Police officers are often the first decision makers in the bail process, making release or detention decisions shortly after arrest and frequently with incomplete information. The effectiveness of Bill C-14 will depend on whether police and courts have reliable, real-time access to an accused's outstanding charges, prior breaches, bail conditions, and patterns of violence across jurisdictions. National systems such as the Canadian Police and Information Centre are essential tools, but they were not designed to function as comprehensive real-time bail risk management platforms. Gaps or delays in data entry and sharing can lead to inappropriate releases and weaker bail positions before the courts. Modern, interoperable national information sharing is essential if the bill's public safety objectives are to be realized in practice. Stronger bail conditions must also be meaningfully enforced. Our members routinely rearrest the same individuals for repeated breaches, often with limited consequences. This cycle undermines public confidence and consumes significant police resources. Adequate supervision capacity, consistent breach enforcement, and clear feedback to police on court outcomes are critical. While provinces administer bail, federal leadership through coordination, funding, and national expectations can drive more consistent results. Finally, effective bail begins with effective investigations. Modern crime is increasingly digital. When police cannot lawfully and quickly access digital evidence, charges may not be laid, or critical information may be missing at bail hearings. Updating lawful access authorities is therefore a foundational public safety measure that complements the goals of this bill. In closing, the National Police Federation supports the central direction of Bill C-14 and its focus on protecting communities from repeat violent offending. Pairing these legislative reforms with modern information sharing, enforceable supervision, and lawful access to evidence, Canada can build a bail system that is fair, consistent, and genuinely protective of public safety. Thank you, Mr. Chair, and I look forward to any questions.
Thank you, Mr. Sauvé. Ms. Valentino.
Thank you very much, and thank you everyone for the opportunity to speak to you this morning. I'm Kathy Valentino, and first and foremost, I'm from the city of Thompson in northern Manitoba, next stop Churchill. I'm a city councillor there. We have the largest RCMP contract in the province of Manitoba. We're typically #1 in the Crime Severity Index. And I'm here today as the capacity of the president of the Association of Manitoba Municipalities, which represents all 137 municipalities across the province. The AMM is nonpartisan, and Manitoba municipalities are united in supporting legislation aimed at strengthening the public safety system and creating a far more effective justice system, because crime does not respect municipal boundaries or political lines. On behalf of the AMM, I wanted to attend in person to express my strong support for efforts to strengthen bail and sentencing provisions through Bill C-14. Across Manitoba, our residents are concerned about crime. Almost 9 in 10 support bail reform and criminal code changes to address repeat offending. 69% report being personally worried about crime. These concerns continue to grow as repeat offenders are frequently being released on bail. These risks are especially acute in Manitoba, which has among the highest violent crime rates in Canada. Municipalities have long warned about repeat prolific offenders being released on bail, and some recent tragedies underscore why. Last year, near the city of Portage la Prairie, Mayor Knox spoke publicly about a young woman who was tragically killed by an alleged impaired driver operating a stolen vehicle. At the time, the Manitoba RCMP had an arrest warrant for the accused for failing to comply with release conditions. More recently in Brandon, Manitoba's second largest city, Mayor Jeff Fawcett raised concerns after police responded to a machete assault near an elementary school, prompting a lockdown while the kids were on the playground. The accused was already under release conditions. And since 2021, breach and failure to comply charges in Brandon have increased by over 20%. Winnipeg has seen similar patterns. Mayor Scott Gillingham has pointed to an offender who, still just in his mid-20s, was convicted of 24 violent crimes over 11 years and violated bail or probation conditions 12 separate times. Taken together, these incidents underscore the need for strong reforms to deter crime and prioritize our public safety. Across Manitoba, our police are repeatedly arresting the same individuals and frontline workers, including our firefighters, paramedics, transit, hospital, and bylaw staff are regularly exposed to them. Being assaulted on the job is unacceptable, and it affects morale, retention, and service delivery. Bill C-14 must include strong protections for first responders, similar to those for peace officers. These include higher penalties for aggravated assaults against paramedics, firefighters, and other frontline staff. We strongly are welcoming the bill's aggravating factor provisions. More broadly, this isn't about detaining people without reason or locking people up and throwing away the key. It's about recognizing patterns, assessing risk, and putting public safety first. Municipalities welcome the acknowledgement that bail reform is necessary. Proposed measures such as expanded reverse onus provisions and stronger sentencing tools are critical to our community's safety. Municipalities would also support broader measures to address repeat offending, including property and retail crimes. However, success will not be measured by this legislation alone. The effectiveness of Bill C-14 depends on sustained coordinating resourcing across the justice and public safety system, in partnership with all orders of government, including adequate police visibility, including addressing Manitoba's RCMP vacancy rate, the highest in Canada, support for our first responders to focus on core duties, a court system capacity, including hiring sufficient Crown prosecutors to prevent backlogs and delays, and investments in mental health, addictions, and social supports to address these root causes of crime. Ultimately, all of us here, we want a justice system that instills public confidence, one that protects our communities while remaining fair and effective. You all here, the committee, you have the opportunity to move Bill C-14 forward promptly. Crime does not respect political boundaries, and addressing it requires cooperation across governments. In closing, I thank you for your time and attention, and I too look forward to taking any questions from the committee. Thank you.
Ms. Valentino, thanks very much. Both of you are right on time, so which takes me to Mr. Atlas. You're online. You have the floor.
Good morning, Chair, Vice Chairs, and members of the committee. I am Michael Atlas, Honorary Counsel for the Canadian Urban Transit Association, CUTA, and I'm also General Counsel for the Toronto Transit Commission. I'd like to begin by thanking you for allowing us to appear before the Standing Committee on Justice and Human Rights. We cannot talk about national public safety without talking about safety on public transit. That is why I'm here today to ask you to amend the criminal code, and more particularly section 269.01, to protect all transit workers from assaults by expanding the current protections which currently only apply to transit operators. As the government seeks to build a stronger Canada by amending the criminal code, this is an opportunity to address a long-standing issue for transit workers. Public transit is a shared public space, and it often reflects broader societal challenges, including the mental health crisis, substance use, and economic hardships. Across Canada, transit workers are routinely on the front lines of these realities, and unfortunately, they experience violence and harassment while carrying out their essential duties of providing critical transportation and mobility to the communities they serve. These incidents are growing in severity, affecting employees across every part of the transit system, including operators, station staff, maintenance workers, fare enforcement personnel, customer service agents, and transit security. For example, in 2025, assaults against TTC employees rose to a high of 40 incidents in one single month. That is 40 employees who may be your friends, family members, who left home, came to work, and were assaulted just for doing their job. With the support of the City of Toronto and the Province of Ontario, TTC has been making investments in safety by expanding frontline presence, partnering to launch the Toronto Police Services Neighborhood Community Officer Program, increasing visibility in stations, and more. We've seen the impact of these investments as customers' feelings of personal safety have risen to 62%, which is a 6-point increase from the previous year. However, Assaults against transit workers continue to be a serious issue, impacting the well-being of our essential transit workers, not just in Toronto, but across the country. One assault against a transit employee is one too many. In response, the Canadian Urban Transit Association established a transit safety task force to examine the root cause of violence on transit and identify practical solutions. In 2023, the task force released a comprehensive set of recommendations focused on strengthening safety measures, improving incident responses, supporting workers after traumatic events, and working with governments and community partners to address broader societal factors. A key finding from this work is the need for clear legal recognition and protection for all transit workers. Currently, under Section 269.01 of the Criminal Code, assaults or threats against transit operators are treated as an aggravating factor at sentencing. However, this protection applies very narrowly, limited only to vehicle operators directly employed in driving a bus, train, or other transit vehicle. It does not extend to the many other frontline transit employees who interact with the public daily and face similarly risks of assault. Our ask is very simple. Expand Section 269.01 to include all transit workers who in the performance of their duties and not limit its application just to transit operators. In May 2024, Member of Parliament Bartosz Chagar introduced Bill C-395, which passed first reading, but unfortunately did not advance further. The bill proposed a targeted amendment to Section 269.01 to strengthen sentencing provision for assaults or threats against all transit workers. This change, replacing the term transit operator with transit workers, is simple but significant. It would ensure that all transit workers, not only vehicle operators, are formally recognized as facing elevated risk while performing their essential public duties. All transit workers play a vital role in ensuring the safety of customers and making customers feel safe. They are often the first on the scene during assaults, medical emergencies, and other crises. They protect passengers, they de-escalate volatile situations, and they call for assistance. Assaults against transit workers have serious physical and psychological impacts. They contribute to burnout and make it more difficult for transit agencies to recruit and retain workers. Other frontline public workers receive explicit legal recognition when assaulted in the course of their duties. Transit workers face comparable risks, yet the criminal code does not consistently reflect that reality. This issue has received broad political support, with members from both government and the opposition recognizing the importance of protecting transit workers. Safe public transit is essential to our economy, our communities, and our climate objectives, and it depends on a workforce that feels safe and supported. There's also strong support from transit unions, including the Amalgamated Transit Union. Workers have been clear. Legal clarity matters. Explicit recognition of their role and the risks they face reinforce that violence against them will be treated with seriousness it deserves. Ultimately, this amendment is more than sentencing. It is about confidence. Transit workers need to know that the law is on their side before an incident occurs. We encourage the government to take this opportunity to protect workers, because when transit workers are safe, Canadians are safe. In closing, an amendment to Bill C-14 that would extend Section 269.01 protections to all transit workers would be practical and a measured step towards improving transit worker safety. It reflects the lived experience of workers across Canada and would strengthen public transit systems nationwide. Thank you, and again, I would be pleased to take any questions.
Thank you, Mr. Atlas. Okay, we'll go to start with the 6-minute round, beginning with Mr. Brock.
This is for your attendance today. Mr. Sauvé, C-14 is marketed by this government as a bundle of sweeping reforms. In reality, Canada and law enforcement are not getting this. The bill's stated objective is to make stricter bail laws and address violent and repeat offending and organized crime, and tougher sentencing laws for serious and violent crimes. This must be a deja vu moment for you, Mr. Sauvé. As you recall, this was the exact messaging we heard from Justin Trudeau and David Lametti, our former Justice Minister, on the passage of Bill C-48. Both promised Canadians and law enforcement that they were listening, and adding more reverse onus charges to serious criminal offences would lead to a greater number of violent repeat offenders being detained. The explosion of criminality over the last 3 years proves this government's approach was wrong. Although you are on record of being supportive of C-48 as being a positive first step, are you now guarded with C-14's addition of more reverse onus provisions to criminal charges?
Not at all guarded. First step leads to second step, which hopefully leads to third step. And I think we're also on record about talking about how when you talk about bail and the administration of justice, it is a partnership.
Would you agree with me on 48, there was no second and third step by this government?
Well, what I'm suggesting is here we are at the second step.
A second attempt, maybe even a third attempt at bail reform. Started with the disastrous addition of the principle of restraint in Bill C-75. C-48 was a failure. Let's hope 14 brings necessary changes to law enforcement and Canadians. Regarding bail, 14 attempts to diffuse outrage for the principle of restraint that requires judges to release the accused at the earliest opportunity on the least restrictive conditions. It adds a line to clarify the principle does not require the accused to be released. Do you agree that Canadian judges already know that principle?
I think you would have to ask judges about that question, and I'm just a cop.
Over 50 pages long, C-14 only addresses a sentence increase to one criminal offense. Over the course of 10 years, violent crime is up 55%, firearm crime up 130%, and sexual assaults up 75%, to name a few. Yet this tone-deaf government saw fit to increase the penalty for contempt of court from 6 months to 2 years less 1 day. Contempt of court is the refusal of a witness under subpoena to attend court to give evidence. In your decade-long career in policing, how many contempt of court investigations were you involved in?
Personally,
Yes.
I haven't been involved in a contempt of court.
Zero. And I've got almost 20 years of crowning in the Ontario criminal justice system, and I had 0 prosecutions. Extortion is one of the fastest growing crimes in Canada and is spreading fear across this country. The data is clear. Since the Liberals took office, extortion has surged by more than 330% nationwide. In BC alone, extortion is up 582%. In Surrey, their mayor is asking this government to declare a national state of emergency. That city is under siege. Its citizens are terrified, yet 14 only mentions extortion once, that extortion convictions are to be served consecutively to arson arising from the same event. Do you think this government should have introduced mandatory minimum penalties to this rising crime?
I think from my experience, from what I've seen in my 20 or so years in policing, mandatory minimums haven't worked.
Then to increase the significant penalty for extortion that's currently in the code would be a proper step instead of contempt of court?
Well, I thought we were here to talk about bail reform.
But it's not just bail reform, it's the bail and sentencing reform package. That's the title of C-14. If you don't want to opine on that, officer, that's fine. Or sorry, Mr. Sauvé. Do you think the government missed the mark in not legislating in C-14 consecutive sentences for child sexual offenders?
When we talk about consecutive sentences, again, I would love to see consecutive sentences. As you know, Justin Bourque was the recipient of consecutive sentences which were overturned to be concurrent sentences not less than a year and a half ago. So I think in that perspective, I would prefer to see consecutive sentencing for egregious crimes.
Do you think the government missed the mark in not legislating in C-14 any pushback against the Supreme Court of Canada's odious ruling that consecutive periods of parole ineligibility constitute cruel and unusual treatment for those convicted of a number of first-degree convictions?
Parole eligibility and ineligibility, I think, is a broad topic, and we're actually on record about talking about mandatory parole and the Conditional Sentencing Release Act and how that should be looked at and modified, and perhaps Canadians would feel safer if they knew that offenders, especially violent offenders, were mandated to spend their entire sentence behind bars versus being eligible in 66% of the time.
Thank you, Mr. Sauvé.
Thank you, Mr. Brock. Ms. Latanzio.
Thank you, Mr. Chair, and thank you to the witnesses for taking the time to be with us this morning and helping us do our work on this very important piece of legislation. My first questions will be directed to you, Ms. Valentino. You've spoken in support of targeted and workable reforms. From a municipal perspective, how important is it that Parliament focus on measures like clearer direction and bail direction and expansive reverse onus for repeat violent offenders rather than the broad changes that may sound tough but don't deliver on the ground?
Manitoba municipalities in particular, that's very important because we want the strength to the reverse onus to happen because we're seeing more and more that it's the repeat offenders that are continually getting out quicker and creating crime in our communities. So I think that that's important for Manitoba municipalities, that that's a part of the bill that's looked at, absolutely. And you have to work in partnership with the provincial government also to ensure that it works downwards to the municipalities through the province also.
We've got that loud and clear that it's a collaborative work between federal, provincial, and municipal governance. Some critics argue that C-14 does not go far enough. Based on your experience representing local governments, how do you respond to the claims that this legislation is limited to make a real difference in our communities across the country?
Bill C-14 is far more than what we have now, so it will definitely make a difference in our communities in Manitoba.
Okay. Municipal leaders such as yourself are responsible for community safety but do not control criminal law. So how does Bill C-14 help give municipalities greater confidence that repeat and violent offenders will be dealt with more effectively by the justice system?
Because we feel that it will free up our RCMP so that they'll have more boots on the ground and a presence in our communities and start to do more proactive policing, working in partnership with municipalities with some of the programming that municipalities are paying for and doing, as such as community safety officers and programs. So it will definitely make a difference in our municipalities for sure.
And in your opinion, how does Bill C-14 strike the right balance between strengthening accountability for serious offenses and ensuring that decisions remain fair, practical, and legally sound?
I'm not in the justice system, so I can't say how that would work parallel, but I know for municipalities, we feel that Bill C-14 is in the right direction moving forward, and the data and what comes of it we will see, and the difference in crime in our streets we'll be able to see how it's working.
And what would you say to Parliament about the importance of moving Bill C-14 through committee efficiently so municipalities and communities can see these changes implemented without unnecessary delays? We
want the committee to move this bill forward very promptly and very quickly. And some of the real-life examples that I've spoken to, we're actually seeing, innocent people that are now dying because of repeat offenders getting out quickly. So it will make a difference, and it can make a difference quickly, and lives will be saved if we can move this bill forward to make our streets safer, especially in Manitoba that I'm speaking for.
Thank you. Mr. Sauvé, over to you. So in your opening remarks, you spoke about resources. So Bill C-14 is one step to a broader public safety solution. You have also spoken about the need for better coordination and resources. Can you explain why it is important that provinces and territories also play their role in implementing these reforms and supporting police?
Certainly, and I'll use just one simple example. I was in New Brunswick a couple of months ago, and their pretrial detention facilities are running at 153% vacancy. So a judge, a judicial justice of the peace, a Crown, will have to take that in consideration as they think about bail and maintaining someone in custody or releasing them on bail. Not enough places to put offenders pretrial. So that's a provincial investment, a requirement for a provincial investment, but also, it could be a federal leadership thing where you guys take the ball and you start running with it.
You have identified the need for better data sharing and monitoring of accused on release. In this context, how important are the bail and sentencing changes that we see now in Bill C-14 to improve outcomes for both victims and frontline officers when coupled with these supports or these suggested supports?
Well, we're not at the information sharing stage yet, right? So there's some form of real-time cross-jurisdictional, and as my fellow witness here mentioned, crime does not respect municipal or provincial boundaries, and having court systems that don't talk to each other between Manitoba and Alberta, where a police officer in Calgary or a police officer in Winnipeg cannot see what court provisions or what court enforcements or what bail provisions have been stayed or are still outstanding, that has an impact on crimes that are committed in cross-jurisdictional areas.
And finally, to you, Mr. Sauvé, finally, what would you say to this committee about the urgency of moving Bill C-14 forward so that police services can begin using these updated tools immediately and communities can see improved safety without unnecessary delays?
Short answer, please.
I think it's urgent that you get it done.
Thank you.
Thank you. Mr. Fortin.
Thank you, Chair. Mr. Sauvé, Ms. Valentino, welcome to our committee. Thank you for being with us. Mr. Sauvé, my colleague, Ms. Latanzio, asked you a number of questions, and I heard I was going to ask you those, so I've gained a bit of time, but I'll go a bit further on those. As a police officer, I think that the members of your federation must understandably be frustrated seeing the same offenders being arrested for similar crimes. And we need to fight against repeat offending. I think C-14 is a step in the right direction. Can we do any better? We always can. But I do think it is a good step in the right direction. In an ideal world, we wouldn't put everyone into prison. There would be no one in prison. In an ideal world, when someone commits a crime, we succeed in rehabilitating that person, make them understand what should be done. So do you agree with me in saying that the final objective should be that people who have committed offensive should not repeat offend? I would suspect that the answer is yes. And if that is your answer, I would ask you, what are the most urgent measures that need to be put in place to rehabilitate these individuals committing offenses? Thank you for the question. That's a good question. I'll answer both in English and French.
The Canadian legal system, the Canadian justice system is built on the foundational principle of rehabilitation, not incarceration. So with that being said, where are we failing in that system? So for example, post-sentence in custody, whether it be provincial or federal custody, are we actually investing in rehabilitation of those offenders? Are we preparing them for a productive life once on parole or once completed their sentence? That I haven't seen. We haven't seen investments within for, a vocational training program, housing assistance program on post-sentence release or on probation post-sentence. So can we do better there for those who are incarcerated? Yes.
And I'll ask you this question in French, but please feel fully free to answer in English. But which measures exactly? Because when people are incarcerated after receiving a sentence, unless I'm mistaken, I think there is a program that's triggered to work with reintegrating them into society, to help them learn job training, etc. But when they're in pretrial custody, the way I understand it is that there is no rehabilitation program. And also, I see that these people are very numerous, and they are in pretrial custody for a long lengths of time. I think that another witness told us that there were 75% of people held in provincial prisons have never been convicted of a crime. It is all pretrial detainees. So I would ask you, doesn't that speak to a problem in our justice system? So what can we do specifically? You are working with these individuals day in and day out. So they have a trial and they're convicted, and then after a few months or years, they reoffend. I'm sure you have much more expertise than I in this domain. So what should we do with these people? How should we act to prevent reoffending?
Non, c'est intéressant.
That's interesting. And I really think that is a question for a lawyer. But I will give my opinion.
Awaiting conviction. Est-ce qu'on a le droit de te mettre dans une centre de formation pour une vocation? Convicted, le juge il peut te donner des.
The judge can intervene to trigger job training, etc. So I really do think this is a question for a lawyer, if it is possible to do that before a conviction.
Right, so that's my perspective on that, but I don't know if I'm right.
Je vous remercie.
Thank you. That is an excellent point. That issue can be complicated. So if they are acquitted, of course, there's no problem. It means that they would not have committed the crime, or at least in theory, they would not have committed the crime they were accused of. But if they are convicted, they will have to fulfill a sentence. And there are other problems involved in calculating the length of that sentence, and we could come back to that. But anyway, they're convicted, and they have carried out part of their sentence before and then after the conviction. So if they have 2 years of sentence to serve, shouldn't there be a rehabilitation process put in place? And if so, do you have any idea regarding that? You were a police officer and you've worked with these individuals. So in your opinion, is there something that should be done for that? Well, there are provinces and territories currently that are considering doing mandatory treatments to put them into mandatory treatment. So that is a rule and a budget that is under provincial jurisdiction. It's a decision for provincial and territorial governments. But if the federal government could intervene, that would always be good. Thank you, Mr. Fortin.
We'll move into the second round for 5 minutes each. Mr. Lawton, starting with you.
Thank you very much, witnesses. And Mr. Sauvé, it's good to have you back again. People may recall you testified as a witness before our study on bail, which the Conservative team initiated, understanding the urgency of this issue. And I'm very grateful not just to have you and your other fellow witnesses here today, but also that our Liberal colleagues have allowed us to finally get to work on reforms that you and other police have been calling for across the country for many years now. I want to return to C-48. Because you were, and the federation you represent, were very, very optimistic on C-48. But when you testified earlier before this committee in September, one of my Liberal colleagues had asked you how C-48 had improved the safety of victims and the safety of officers on the front line. And you said, quote, "I don't think they have." So we have had false starts before. If we are to take our cues from your experience in this regard, how can we make sure that this bill, C-14, is not retreading old ground in that sense? How can we make sure that this is actually living up to the promises?
That's the challenge, and whether it's C-75, C-48, or C-14, and we've said in numerous submissions as well as numerous pieces of testimony that, this justice system, when you're talking about bail or you're talking about sentencing, it's a joint partnership. The federal government can lead and govern with respect to the criminal code, but your provinces and territories administer. And without their joint partnership and funding for adequate Crown attorneys, adequate judges, adequate pretrial detention facilities, adequate probation officers, adequate resources to administer, then we're setting ourselves up to fail, regardless of what system we put in place in the code.
Recognizing that, sadly, in my role, I can only deal with the issues that are in federal jurisdiction, in this context, the code, you indicated that you view C-14 as a second step, but you suggested in your earlier response to Mr. Brock that there should be a third step beyond that. So if we are to get this right, what should be in the bill that's not in the bill? What would you like to see building off of this?
Well, when I speak about a third step, so if we're talking about first step, C-48 now, or C-14, second step, if you recall last, I think it was in November when we were studying the bill, right, one of the recommendations or one of the pieces that we put forward is, can the federal government be a leader in consistent training for judicial justices of the peace, or consistent training in application of C-14 or C-48 or reverse onus provisions, so that you have consistency across the board in provincial court systems. You could convene a meeting of, instead of a first minister's meeting, you convene a first attorney general's meeting, so that there is consistency across the board, and every police officer and every court across the land is actually operating from the same premise.
The NPF has previously recommended ensuring that bail hearings are only presided over by justices of the peace that have legal background. Is that something that you would like to have seen in C-14, and perhaps something that could be included as an amendment in the criminal code that you would welcome?
I think that's something that would be welcome. Whether it can be done and whether it would withstand scrutiny is the other question. But I think, consistency, whether it's JJPs or only judges or only JJPs, or whether they are folks who are consistently trained to the same standard across all jurisdictions, would be a welcome.
I've heard anecdotally from officers that I've spoken to in my riding that they do see a very clear connection between the really bad bail decisions that we hear about that often make the news and cases that were presided over by JPs rather than judges. Is that consistent with your experience as well?
But it's also who's arguing the case on behalf of the Crown. So, for example, as a police officer, in some cases, I was arguing the case and writing the case for the primary, the secondary, and the tertiary grounds. So, in that case, let's have some consistency across the board. Should it be police officers in some cases that are acting on behalf of the Crown, or do we need more resources so we have consistent arguments that are going forward to consistently trained JJPs or judges at hearings?
In the Conservatives' Jail Not Bail Act, which we had hoped to receive collaboration on from the Liberals, we had urged, listening to concerns that have been raised by police, the removal of the ability for people who are themselves convicted of serious offences vouching for people as sureties. Is that something that you would support including?
Again, it's an interesting topic to explore. I don't know whether it would withstand scrutiny.
But would you support it if it did?
I'd have to look a little bit more into that one. Yeah.
Thank you.
Thanks, Mr. Lawton. Okay, over to Mr. Chang for 5 minutes.
So my first question will be directed to Mr. Sauvé. From your perspective, where do you believe Bill C-14's bail reforms address the real gaps, and how do they align with what police have been asking for?
Well, to start, I think the clarity around reverse onus provisions and placing a lot of reverse onus on those accused of more serious and perhaps random and unprovoked attacks to actually declare why they are worthy of bail. That's a start. And then you have some challenges, or not challenges, but good pieces, again, to start with when you're talking about organized crime and mandatory firearms bans and mandatory those. So the challenge is going to be, from a law enforcement perspective, is when someone does achieve a reverse onus provision and is released on bail on their own recognizance or some form, and a police officer finds them violating it, what happens then? And are we going to end up in the same situation we have today, where courts or crowns are not taking breaches of bail provisions as seriously as other offenses? So, is it your second strike? Is it your third strike when we are going to deny you bail? So those are all good starts, but, the devil's in the details and the proof's in the pudding.
Okay. Thank you. And you have stressed the importance of ensuring courts have the tools to keep repeat and violent offenders off the street. How do you see Bill C-14 strengthening public safety and community confidence in bail decisions compared to the current framework or current system?
Well, as just mentioned, right, you are expanding and strengthening the opportunity for reverse onus provisions. And when you talk about repeat violent offenders, that's who it's going to impact. And those are the ones that are going to be seeing a more difficult road to achieve bail than just your average everyday first offender.
Thank you. And my Final question to you is that would you urge all parties to pass this Bill C-14 as soon as possible to protect Canadians?
I would.
Thank you. So my next question goes to Mr. Atlas. Looking specifically at the bill's bail reform for repeat and violent offenses, can you acknowledge how these changes strengthen the ability of court to better manage risks in communities, including transit systems?
Really, the suggested change that we're talking about is really just for transit workers, and to try to make sure that the criminal code recognizes transit workers in the same way that they recognize transit operators. But to answer your question, I don't speak for CUDA on this issue, as it's outside the bounds of CUDA, but myself, I would agree that it does help municipalities.
Thank you. You represent transit agencies that work closely with municipal and provincial partners. How important is it that provinces and local governments play their part in enforcement, support, and implementation rather than expecting the federal bail reform alone to solve all complex transit safety issues?
So it's critical. This is about a multidisciplinary approach. So it takes everyone to assist in ensuring that you have a safe public transit system, all levels of government and enforcement, as well as criminal code amendments.
Okay. And my final question to you is that would you agree that moving forward with targeted workable reforms like those in Bill C-14 is preferable to delaying actions in pursuit of broader changes that may sound tougher but risk not delivering real improvement for transit workers?
I would.
You urge all parties to pass this Bill C-14 as soon as possible?
Yes.
Thank you. And my final question goes to Ms. Valentino. So municipalities are often on the front line when it comes to impact of repeat and violent crime. Can you explain why the Association of Manitoba Municipalities publicly welcomed Bill C-14 and why this bill and sentencing reforms matter for community safety?
Thanks for the question. So we're hearing first and foremost from residents on our Manitoba municipalities, and AMM researched a survey, and it was clear that 9 out of 10 of our public is feeling unsafe. So we support this wholeheartedly because we see these repeat offenders repeatedly doing the crime in our communities. And as stated before, our RCMP and our frontline workers are all being subject to these repeat offenders. And if we can not have them, if there are stronger conditions for them, if they're a repeat offender to not get out, then we'll be able to have more resources, boots on the ground with RCMP to keep our municipalities safer, because the feeling right now is that our streets are unsafe because of the repeat offenders.
Thank you very much. Okay, so we have about 7 minutes left, so I'm going to give Mr. Fortin his 2.5 minutes, and then I'm going to give Mr. Barber and Ms. Dillon 3 minutes each.
Merci, Monsieur le Président.
Thank you, Chair. Mr. Sauvé, in your witness testimony earlier, you talked about how important it is to have enough information for police officers in their work. As far as you know, do statistics or numbers currently exist on repeat offending for people who are released on bail versus people who were convicted and then served a sentence? Yes and no. It depends. For example, if you're in the city of Montreal and we're talking about someone who is a repeat offender, you have all the information locally. But if you change a jurisdiction, it can become problematic between Quebec and Ontario or between different provinces. So it's a problem of exchanging information. So it would be important to have a program in place that would make it possible to transfer this information. Yes, absolutely. Thank you. Ms. Valentino. I don't want to blame you in any way, so please don't take it that way, but municipalities in Manitoba, Quebec, and everywhere equally are faced with these cases of violence and repeat offending. I was chatting with Mr. Sauvé about it earlier, about the importance of constructive and effective rehabilitation for offenders. Unfortunately, it's not always available. We just have a few seconds left, but in your opinion, what can be done where there is not enough investment in this rehabilitation above and beyond funding. Are there other reasons for why that is happening?
Sure. So I think that it speaks to it clearly that it takes all orders of government that have to make this work and have a little bit of skin in the game. So the federal government, the provincial governments, and then the municipalities also. If we're talking about some kind of reform or programs, municipalities are already doing that on their own and on their own dime for their taxpayers. They're creating programs in their communities to try and, get at-risk youth to do low-cost recreation things. So they're already trying programs of rehabilitation for criminals and for keeping their streets safe.
Thank you. And quickly, can you talk to us about crimes committed by adolescents, by teenagers in your region?
Mr. Fortin, we're out of time, unfortunately. I'm sorry.
We need time for translation, Mr. Chair.
I know. I've given you a little bit of extra time.
Thank
actually,
you.
But yeah.
Merci.
Fortunately, I don't make the rules. I just have the unfortunate and unenviable task of enforcing them. So, okay. So
I understand.
3 minutes, and then Ms. Dillon for 3 minutes.
Ms. Short, so we'll try and go quick. Mr. Atlas, welcome. I understand you are legal counsel for the Toronto Transit Commission.
That is correct.
I got into provincial politics about a decade ago because I'm very passionate about the TTC. It's been my lifetime work to try and connect Shepherd West Subway Station and the Shepherd Yonge Subway Station, which crosses through my riding of York Centre and the great riding of Willowdale. I certainly hope that maybe you can try and assist me with that.
I am also a member of that same riding.
I'm honored to represent you. Mr. Atlas, I note a CBC article from November 26, 2025, that says that in the last decade, physical assaults are up 160% on the TTC, and all violent crime is up 127%. That's notably since the year 2015. Does that sound right?
So I don't know the numbers, but yes, it's definitely increased.
I can think of something that happened at 2015, that is the election of this present Liberal government. But is there another reason why do you believe that we see such an uptick of violence on the TTC?
I don't know if I have an answer for that. I think when you look at how we're trying to solve the problem, you're looking at it through multiple different approaches. You're looking at mental health crisis, you're looking at substance abuse, and you're looking at homelessness. And so the way, at least from a TTC standpoint, is we're looking at all of those disciplines, and I don't know if there's one reason over another of why you've seen it.
I used to take the subway to work every day, both when I worked downtown and when I worked at Queen's Park. But unfortunately, because of all the incidents, the subway is just simply no longer reliable in the city of Toronto. I did look at the mental health component. According to the Toronto Sun, 1 out of every 4 incidents where a person is involved is due to a mental health issue. To your knowledge, is that addressed in Bill C-14?
I'm not aware of that being addressed.
Address. I want to ask you about special constables. How is that working out, or do you believe that they need greater law enforcement ability, or they need to be armed, perhaps?
No, I personally don't think they need to be armed. I think special constables do a great job of providing safe and secure transit system. So I don't necessarily think they need to be carry weapons.
It's very sad to me that in the city of Toronto, parents no longer feel safe for their children to take the TTC on their own. I think the TTC is such a landmark in our city, and it's very, very sad that we are here today. And I also note that primarily the mental health component of this has gone up after the pandemic response. Is that correct?
That would be, I think that's the perception, yes. I just want to reiterate that the TTC remains a safe system, so you can encourage your friends' kids to continue to take TTC.
Thank you, Mr. Bauer. Ms. Dillon, over to you for 3 minutes.
Thank you, Mr. Chair. I will start with Mr. Solvay. Thank you for your testimony, Mr. Solvay. You were being questioned about your experience as a police officer, as an officer, and you said something interesting. You said in your experience, you did not see mandatory minimum sentences as being a deterrent. Can you please expand a little bit on that? Thank you.
Yeah, and I'm not against mandatory minimum sentencing, and I think most police officers are not against mandatory minimum sentencing. My experience has been it's very difficult at trial or with a Crown to proceed and make the argument for a mandatory minimum sentencing or for a judge to award a mandatory minimum sentence. So that's been my experience. We've tried on a number of occasions and haven't been successful. It's an extremely uphill battle.
And you said that you spoke about data gathering and sharing. Can you talk to us a little bit about what you would see more helpful to prevent restrictive territorial jurisdictions? Because you've mentioned a few times that it's very important that there's a collaborative effort across Canada. If you can talk to us about that.
If we just talk about one jurisdiction, so for example, all of my experience in the Lower Mainland of British Columbia, so the BC court system operates on one software platform, which is fine. And we arrest someone for break and enter. They are released on bail because it's a first offense. Over the next several weeks before their court appearance, they violate that bail or they breach their conditions for whatever reason. So by the time they deal with the substantive offense of break and enter, which might lead to a guilty plea in exchange for a stay of proceedings on the numerous breach of bail violations, all a police officer is going to see on a next offense or the next time someone commits a crime is the conviction for the break and enter. They won't see the fact that they were charged and had stays of proceedings on the numerous bail violations. And it gets even more compounded if you change jurisdictions or if you change provinces. So a Crown Counsel in Lethbridge, Alberta may appreciate knowing that someone who's been arrested for break and enter has a conviction for break and enter, but also has 17 stayed charges for bail violations in a different jurisdiction or a different province. That might change their argument on bail, and it might change a JJP's decision-making process on granting bail.
Perfect. And as we've seen, reverse onus is also something that is going to be expanded when it comes to there's intimate partner violence and, for example, auto theft, violent auto theft. You would like to see, I'm sure, this bill quickly passed for these reasons. I
would. Let's get step 2 over with and move on to step 3 and get all jurisdictions working together.
Thank you, Ms. Dillon. We're going to have to stop there. I just want to say thank you to all 3 of the witnesses, not only for being here today, but for your service. We're all incredibly grateful. And I will take issue with only one thing that was said and that was Mr. Sauvé. He said, "I'm just a cop." You're not just a cop, sir. You're a police officer, and we all owe you a debt of gratitude, as with all of your colleagues. So thank you all for being here. We'll suspend for a moment. We'll get the next panel ready.
Okay, so while they're suspended, we will tune into the House. Dun, dun, dun.
A sense of justice. They don't feel safe in their communities. And why is that, Mr. Speaker? Well, let's look at some of the facts. Under this government, so since 2015, over the last 10 plus years, violent crime is up 54%. Homicides are up 29%. Sexual assaults are up 76%. Gun crime, Mr. Speaker, is up 130% since this government took office. This one is unbelievable. Extortion has skyrocketed up to 330% over its 2015 levels. Fraud, and we all know individuals who have been touched by this, fraud has increased by 94% over the last 10 years. These are absolutely horrific numbers, but it's not about the numbers. Behind every one of these statistics, Mr. Speaker, are real people, real victims, people from our communities, our friends, our family, and they are feeling the very real consequence of soft on crime policies undertaken by this Liberal government. All too often we learn that the criminals committing these crimes have a lengthy criminal record. And many of these crimes, after commission, they're out on bail. Why are they out on bail, Mr. Speaker? It's so frustrating for Canadians when they hear someone who's committed a serious sexual offense or another offense, and then they find they're out on bail. Why are they out on bail? How does this happen? How is it just? How is it safe? Well, they're out on bail because this government in Bill C-75 changed the law. They introduced a principle of restraint. And what that does, it ties the hands of judges, and it says that the will of this Parliament is that individuals be released at the earliest possible opportunity, and they're held in the least onerous provisions. They're held as loosely as possible, which means rather than being in custody, they're out on the street. You know who this frustrates? It not only frustrates the victims, it not only frustrates our community, it frustrates the police. Imagine arresting someone for a gun crime or arresting someone for auto theft. And you do the work as a police officer, the individual's brought before a judge, and before you finish your shift, that person is back out on the street. Mr. Speaker, that is not right. And the Liberals, they continue to defend the indefensible when it comes to soft on crime laws like Bill C-5 and Bill C-75. I just spoke about Bill C-75, but Bill C-5, Mr. Speaker, shockingly eliminated mandatory jail time for violent gun crimes like robbery with a firearm and extortion with a firearm. So under this government, their so-called criminal justice legislation, they eliminated mandatory jail time for those serious gun crimes. Now, let's reference back to what I said a few minutes ago. Let's see how's that working? How is that approach working of letting people out on bail that have committed serious crimes like Bill C-75, and if someone is sentenced, saying they're not going to have mandatory jail time under Bill C-5. What is the combined effect of that? Maybe gun crime's down. Let's take a look. No, unfortunately, gun crime is up a mere 130% under these policies. This is a serious indictment now. The facts are in a serious indictment of this government's agenda. Conservatives have put forward common sense legislation to undo some of the damage done in Bill C-5. We introduced the Protection Against Extortion Act to restore mandatory jail time for the offense of extortion with a firearm. We introduced the Combating Motor Vehicle Theft Act so that convicted car thieves can no longer serve their time from the comfort of their home. They can now simply walk out the door and steal another vehicle. Of course, the Liberals voted against it. Bill C-5 weakens sentences for producers, importers, and exporters of dangerous drugs, the drugs that are affecting people throughout all of our communities.
Okay, I hate to interrupt him because he's cooking right now, but we're going to get back to the Justice Committee, which should be any second here. Oh, it's still suspended.
Produce and export dangerous Schedule I drugs like meth, heroin, cocaine, and fentanyl. But the Liberals' soft on crime policies haven't made anyone safer. And in fact, the numbers say that it's just the opposite. They have done much worse. And that's why, in speaking to this legislation today, we have to be aware of what the Liberals have done. They've introduced in this legislation, embedded in this legislation, a further deterioration of the will of Parliament when it comes to serious offenses. The will of Parliament has been...
Okay, there we go. Committee's back.
Remarks, and Dr. Sundberg, since you're in the room and I'm looking at you, I'll turn the floor over to you.
Thank you very much. Mr. Chair, honorable members of the committee, thank you for inviting me to appear before you again to speak on bail and sentencing reform as presented in Bill C-14. By way of a brief context, I'm a professor of criminology at Mount Royal University. My work has long focused on border security, immigration enforcement, and transnational crime, alongside scholarship on policing, public safety, and security. Prior to academia, I served for over 15 years in federal border security and immigration enforcement, including in advisory roles with the federal government. To begin, I want to be clear, I support this Bill C-14. In my assessment, it is measured, legally cautious, and respectful of judicial independence while responding to the public's real concerns about repeat and violent offending and the credibility of our bail decision-making. Canadians expect Parliament to ensure that people accused of serious violence, organized crime, and repeat offending are carefully managed by the courts, balancing an accused's charter rights with the rights that Canadians have to live free from fear, intimidation, and victimization. I also want to acknowledge the testimony from this past October, British Columbia Regional Chief Terry Teague of the Assembly of First Nations. He reminded us that bail and sentencing reform must not deepen inequalities or shift new burdens onto Indigenous communities that already experience disproportionate harm. A credible public safety agenda must include sustained support for Indigenous communities and Indigenous-led and informed solutions. I'm here to speak on I want to focus on one discrete issue that can be addressed in a narrow and defensible way. Canada is one of the most immigration-dependent societies in the world. We have a large foreign-born population, and at any given time, a very large temporary resident population, students, workers, and visitors living in our communities across our country. Recent federal reporting has placed the temporary resident population at roughly 3 million people. When even a small fraction of foreign nationals are implicated in serious offending, terrorism-related activities, organized crime, extortion violence, trafficking, or exploitation, the harms are real, and the public expects a meaningful response at the earliest justice system decision point. In my belief, it's bail. And there is a human point to this. Many newcomers and first-generation Canadians come to Canada to escape violence, intimidation, corruption, and organized crime. When those same threats follow them into Canada, it undermines confidence in both our justice system and our immigration system. My recommendation is simple. Align bail law with Parliament's seriousness structure in the Immigration and Refugee Protection Act. Specifically, I propose a narrowly tailored reverse onus provision so that when a foreign national is arrested and charged in a manner that, if convicted, would render them inadmissible under IRPA's security and terrorism, human or international rights violation, serious criminality or organized criminal provisions, the onus shifts, and they must show cause why they should be released. Why does this matter at bail? First, attendance in court, conditional status, and conviction-linked inadmissibility consequences can materially affect flight risk, compliance, and enforceability. Second, public safety. These are Parliament's highest concern categories of misconduct by non-citizens temporarily in our country. Third, public confidence. Where Parliament has determined that certain conduct is fundamentally incompatible with remaining in Canada, Canadians reasonably expect bail decision-making to reflect that seriousness while remaining fully compliant with fairness and due process. To be crystal clear, this is not automatic detention. It is a narrow, show-cause mechanism that preserves full judicial discretion and requires the court to apply the discipline analysis under Section 515, sub 10 of the Criminal Code with the onus structure appropriately for a small yet high-risk category. When even a small fraction of foreign nationals are implicated in serious offences, terrorist-related activity, organized crime, extortion, violence, trafficking, or exploitation, I've already read that part. Sorry, Mr. Chair. I'll close. In closing, Bill C-14 is a strong and necessary step forward. I also believe the committee has an opportunity to strengthen it without overreaching by adding one carefully drafted reverse onus provision for foreign nationals in the IRPA Section 34 to 37 inadmissibility bans. Again, to give effect to my earlier stated recommendations, I propose wording consistent with what I provided this committee in the written response last week, namely that a new reverse onus paragraph be added to Section 515, 6A of the Criminal Code. When applied, the accused is a foreign national, as defined under subsection 2.1 of the Immigration and Refugee Protection Act, and is charged with an offence such that, if convicted, the accused would be inadmissible to Canada under Section 34, 35, 36, or 37 of the Act. The reverse onus should apply. Thank you, and I welcome your questions. Sorry for the stumble on my...
It happens. It happens. If you hadn't have done it, I would have done it, or somebody else. Don't apologize. Mr. Murias, over to you, sir, for up to 5 minutes.
Oui, bonjour à tous. Je vais m'exprimer en français.
Good day, everyone. I'll be speaking in French. Thank you for the opportunity to speak before the committee. I will be focusing entirely on the part regarding teenage offenders, so the Youth Criminal Justice Act. That is my area of expertise, and I will be focusing on that. So I will not be speaking to other provisions under the Criminal Code. I have been working with this demographic for 14 years. I am very passionate about my work. And we have seen a big change over those past 14 years in the offenders and the profile of young people who end up before the courts. I would also like to start by saying that there are a number of positive things in the Youth Criminal Justice Act. It came into force in 2003, and we have observed many positive effects. And in C-14, there are also positive implications for this act. So there are some dispositions that do need to be updated on the Youth Criminal Justice Act. I think they can be updated, and this would make it possible to better respect the act. You know, one of the aspects of the Youth Criminal Justice Act is that it is one of the best ways to protect the public. It is in Section 3. It is rehabilitating young offenders. This was decided by the Supreme Court in 2007 regarding Section 7. So law in general must respect this preventive principle as being the most effective way of protecting the public. It is also moral. And we know that quick and effective and intensive intervention is the most effective way to stop young offenders from reoffending. We know that that is what is effective. It's not a political issue. It is proven by data. So science and data can be used to prove this as well. At this time, we are seeing a change in the profile of young offenders, as I mentioned. There has been an increase in the severity of offenses. We are seeing the numbers increasing. Since the year 2000, there was a decrease, but more recently we have seen an uptick again in crimes committed by youth. Here are some measures that I believe we can put in place. The first change would be to change the definition of violent crime. What is currently proposed, in my opinion, is not the most effective because it would be necessary to add something regarding firearms. I think that would be appropriate. There's also a list of measures 91, 92, 97, 98, 99, and 101 and 102 sections of the Criminal Code that should be included regarding firearms. This would stop us from having to use an exceptional provision, 3119. So if we modified this definition of violent crime, we should include wording around firearms. This is something that is necessary, especially given the reality we are observing in urban centers. Next, I would like to speak to weekend custody, for example. That is very closely linked to provincial and territorial resources. So I would also propose an amendment in that section so that there is no condition, so it would effectively make this the same as it would be for adult offenders. We know that there is a program that works and it yields results, and it is a program.
I'm going to have to stop you there. If you'll have an opportunity to answer some questions shortly. Mr. Copeland, over to you for up to 5 minutes, please.
Chair, members of the committee, thank you for the invitation. Let me begin with a simple but important point. Canada's public safety issues are real, but bail is not the primary problem. The real issues are repeat violent offenders and the expanding reach of organized crime. We need to address organized crime and national security gaps in enforcement and prosecution, reduce excessive judicial discretion, and pursue selective expansion of non-custodial sentencing options. Over the past decade, we've seen a sustained increase in violent crime, heightened public concern about repeat and dangerous offenders, and growing frustration with what appears to be inconsistent and lenient outcomes. But these causes aren't reducible to one factor. They include Supreme Court jurisprudence, particularly Jordan, which is a one-size-all solution imposed by courts that ought to have been studied and enacted by Parliament for case timelines. It has forced speed at the expense of substance and resulted in thousands of stayed or withdrawn cases. Court backlogs and delay, which inflate remand populations, as already been mentioned today, which actually harden offenders. Organized crime and national security linked criminality, which our tools at present are poorly designed to address. And the striking down of hundreds of mandatory minimums without replacement architecture, and a sentencing framework that relies heavily on broad principles but offers little structured guidance, leaving room for too much discretion and unpredictability in the law as a result. Bail decisions sit downstream of all of this. Bill C-14 responds to real public anxiety, particularly around repeat violent offending, and some of its sentencing amendments may help at the margins. But deterrence ultimately comes from consistency, predictability, and certainty of enforcement and punishment, which are affected by many other things. If we just crack down on bail without fixing sentencing, prosecution practices, and enforcement capacity, we don't get deterrence. We get more remand, more delay, and less legitimacy. And we, in fact, have seen this after Bill C-48's introduction. Excessive reliance on pretrial detention can worsen outcomes, swelling remand populations, putting pressure to plead out, and sentences, if it gets to that stage, get effectively commuted by time served in these dysfunctional conditions. One of the core problems in our criminal law is that the principles and purposes structure affords too much discretion, which undermines predictability and deterrence. It's governed by broad objectives and principles in Section 718 and balancing exercises between these principles that produce variation across courts. Past sentencing commissions in Canada warned about this problem and examined UK-style sentencing guidelines, not rigid grids, but structured ranges and offense-specific guidance, but these were not ultimately adopted. And so we have too much unpredictability, weak denunciation for serious crime, and diminished public confidence as a result. So if Parliament wants to address violent repeating effectively, I would suggest 4 priorities. First, organized crime and national security. Our definition of organized crime is too narrow and difficult to prove. Canada should move toward a pattern-based framework similar to US-style RICO tools. We should create targeted exemptions for Stinchcombe disclosure rules and Jordan case timelines when organized crime and national security thresholds are in play. These are tools that our allies have, which make Canada a target for organized crime and foreign state actors that's being actively exploited and is evident in the rising number of organized crime groups operating here. Second, we need to reduce excess discretion in sentencing dangerous offenders. If Canada will not adopt sentencing guidelines, then Parliament should at least rebalance Section 718's application for serious, repeat, and violent offenses, and make clear that denunciation and deterrence must be given primary consideration for more types of charges, language that Parliament has used before and somewhat in this bill for other offense categories. Third, prosecution policy matters. Hybrid offenses enable Crown discretion, and they're found throughout the criminal code. That could be maintained but tightened by working with the provinces to amend both the federal and provincial Crown prosecution manuals to establish a default presumption of indictment for serious repeat and violent offenses. Fourth, expand serious non-custodial sentencing options. Canada lacks robust long-term non-custodial options that sit between probation and prison. Well-designed in-community sentences
I'm going to have to ask you to
are
wrap
less
up quickly,
expensive,
Mr. Copeland. Yeah.
support rehabilitation and reintegration, and can be highly restrictive and deterrent when properly supervised.
Thank you very much. Okay, so we'll go to the first 6-minute round, starting with Mr. Bauer.
Thank you, Mr. Copeland. Welcome. I read your recent article in the National Post, targeted mandatory minimums required to counter activist judges. You write, quote, a combination of mandatory minimums and stronger sentences for severe crimes and high-risk offenders are justified. Is that correct?
Yeah, I did write that. I think it's one tool in the toolkit as they remove judicial discretion. And that is one of the issues that is resulting, I think, in a too lenient prosecution system.
I'm not sure if you had a chance to really study the bill that is presently before the committee. It's called amending the criminal code, in brackets, bail and sentencing. But there really isn't much sentencing being amended by this bill specifically. While some schemes of the criminal code are being changed with respect to sentencing, the only adjustment in terms of penalty appears when it comes to contempt of justice. That is the only time sentencing is addressed in Bill C-14, which conservatives find remarkable in how deficient this bill is. Are you disappointed that we haven't seen much sentencing reform in Bill C-14, Mr. Copeland?
Yeah, I have written about this before. I think certainly bail is an issue and it needs to be addressed. But when we just focus on bail through the creation of these reverse onuses, you can end up swelling the remand population and not affecting sentencing. And so, as I've indicated in a few of these suggestions provided, we can remove judicial discretion while maintaining it in appropriate ways to make sentencing more predictable and effective.
It's important to note that sentences prescribed by the criminal code or handed down by the judiciary often end up not being the sentences served by those convicted and sentenced to those sentences, in that there's pretrial custody time, often 2-for-1, and these days, in some cases, 3-for-1. And you also have essentially an automatic eligibility for parole after a third of the sentence. So I got to tell you, I'm quite disappointed that it appears as if the government missed an opportunity here on sentencing.
Yeah, I would agree. I think that the bill should be amended, and the government's shown some willingness to do this with the border security bill, where they took out lawful access, but they're studying that further and they're going to move forward with it. So I suggest that significant amendments to the sentencing regime are undertaken. Again, a significant one would be for a whole host of serious, dangerous offenses, change the prioritization of the principles, not just tweaking a few as they've done here.
Write a lot about mandatory minimum sentences. No doubt you followed the Supreme Court in Centerville a couple of months ago, striking down a mandatory minimum sentence in a case involving access and distribution of child pornography. Horrendous set of facts, horrendous materials in possession of those two accused. And apparently, the Supreme Court, I must say majority of the Supreme Court, thought that a mandatory minimum sentence would be unconstitutional here, and that would be 1 year for possession or access. We see nothing on that in Bill C-14. We now see Bill C-16, which I anticipate will come to this committee at some point as well. And in that respect, we do see the government, in fact, watering down the mandatory minimum sentencing provision, in that they propose a safety valve where there would be automatic litigation of the constitutional principle that a punishment cannot be cruel and unusual every single time, and allow a judge discretion not to apply the mandatory minimum. How do you feel about that?
Yeah, I think so. First of all, the case was decided upon this use of a reasonable hypothetical scenario, which are facts not before the court, which I think points to a larger issue here that to properly bring mandatory minimums into the law, you do have to account for the presence of the charter and the philosophy that's prevalent among large numbers of judges on the bench, which I think leaves room for improvement. But there are other options to introduce mandatory minimums but have narrower types of exemptions. So there are a number of factors that you could stipulate wherein a judge could then enact their discretion that doesn't go as far as what's being put forward here. In fact, many other jurisdictions have these in place. So I would like to see mandatory minimums of that nature, but with narrow exemptions.
Mr. Copeland, if I may, very quickly, I want to go to Mr. Somberg. I see your proposal for reverse onus in cases folks to whom the Immigration and Refugee Protection Act applies. But can we talk about sentencing? If you're convicted of a serious crime, we now see or of a crime, we now see situations where judges prescribe more lenient sentences so as not to affect the immigration status of a particular accused. I find that preposterous. I would like to do the opposite and look potentially to revoke a temporary stay by a convicted criminal who is not a resident of Canada. And in fact,
that's all your time, Mr.
That is
Babber.
what Michelle Rempel is proposing in Bill C-220.
That's all your time. I'll give you time just for a quick answer.
Very quickly, I think that the proposals that have been discussed are important. What my effort is to align the spirit, if you will, of IRPA, the Immigration and Refugee Protection Act, where Parliament has made, in my view, some good decisions on what is inadmissible for certain classes of individuals that are not Canadian citizens. And having an incongruency between how the courts deal with the matter and how the immigration program deals with a matter of criminality, I think when we see this conflict in many respects, where we do see justices that are purposely reducing sentences to ensure that someone doesn't fall into the IRPA, in my regard, or in my view, is problematic, and in many respects is somewhat schizophrenic in a way, where we have one side of the legislation and the IRPA saying one thing, and then we see the criminal code saying another thing, and I think that we need to bring alignment.
Thank you.
Thank you, Mr.
Mr. Chang.
Dr. Somberg, thank you for your service. Just last week, every First Minister in Canada, including Conservative premiers, released a joint statement calling on Parliament to move forward on bail and sentencing reform to better protect Canadians and strengthen public safety. Given that level of unanimous federal and provincial agreement, do you accept that Bill C-14 represents a necessary and broadly supported step in responding to the concerns provinces and communities have raised?
I do, and I do believe that the fact that we're having this meeting today, that Bill C-4 was put to the side so that this very important bill, C-14, can be addressed, is a testament to the members of this committee and across the board looking at issues. Are we achieving what everybody wants? Perhaps not, but at least there's some movement forward, and it shows Canadians that there is an urgency that their voices have been heard, in my view, that Canadians believe their voices are being heard, and that when we see cooperation between across the parties at the federal level and across the provincial governments in achieving a resolve, I think this is a very positive move. And part of what we're doing and what we're talking about with Bill C-14 is truly about rebuilding trust and credibility in our system, and this is an important first step. So I think it's positive. I see it as a positive move, and we need more of it.
Okay, so my second question would be, the joint statement was clear that government at all levels expect actions, not delays, on bail and sentencing. So do you agree that targeted reforms like those in Bill C-14, with a focus on repeat and violent offending while respecting core justice principles, are the kind of responsible actions First Ministers are calling for Parliament to deliver now, and why?
I do. I think that Mr. Barber brought out a good point with regards to the sentencing. The Bill C-14 is very much about bail, not so much about sentencing. Nevertheless, one step at a time, and I think that it's very positive to see that there's earnest and for some probably uncomfortable discussion about moving forward so that we can find that balance between an individual's rights and the incredible importance of ensuring safer communities and protecting Canadians from violence, harm, organized crime. And we do need to do more and we need to do better. And I do see a positive move forward, frankly.
Thank you. Dr. Sundberg, when this committee studied bail and sentencing in fall last year, Conservatives themselves invited Mr. Eric Goldkind, a very senior and experienced criminal lawyer from Toronto. Mr. Goldkind told this committee that the principle of restraint is a very good thing, and that Canada should be very proud of how it treats even the worst among us. Given that principle of restraint does not require judges to release accused and has never meant mandatory release, do you agree with Mr. Goldkind that restraint has an important place in our justice system, even as we take steps to better protect communities from repeat and violent offenders?
I think when we see discretion, when we see how in different jurisdictions and in different courts matters are applied, there is a concerning level of inconsistency. Nevertheless, I think the fact that this bill is tabled and being seriously considered by all indicates that everyone recognizes that we do have to do better. And moving forward, I do think that we have perhaps been too liberal in our approach, and we do need to rein in some aspects of our criminal code to and what we're speaking with reverse onus. I think it's very important. Nevertheless, I do think it's important to keep in mind that we and Canadians should know that there is a large percentage of those who sit in our various correctional facilities across this country are there awaiting trial. But the concern comes into when we have omnibus sentencing, where a lot of the charges that would otherwise be put on the record are dealt with separately or brought in, and that can cause some confusion for Canadians. And really about what this should be about is assuring Canadians that the considerations of their public safety and security are being seriously considered. And I can see that some of the inconsistency would lead a number of Canadians to feel otherwise.
My final question to you is that would you urge all parties to pass this Bill C-14 as soon as possible?
Yes, absolutely. I would, and I'm glad to see that it seems that there is a shared urgency to get this forward, and I think that's commendable, and I thank you as a Canadian for, as a voter, I'm glad that that's happening.
Thank you very much. Do I still have time?
You've got 25 seconds.
Well, that's fine.
Yeah. Okay, Mr. Fortin, over to you.
Merci, Monsieur le Président.
Thank you, Mr. Chair. Mr. Sundberg, thank you for being with us. Thank you, Mr. Copland and Mr. Murias also for being with us. Mr. Murias, in your opening remarks, at the end, you quickly were speaking. I didn't understand all of it. Which program exactly were you referring to that should be included in the law instead of being under provincial jurisdiction? I know you were talking about weekend custody and that sort of thing. Could you be more specific, please? Of course. Thank you for the question. Yes. Do you know what is called continuous custody, which means that weekends are also included in custody? This is common for adult offenders. It's under the criminal code, and it's appropriate for a type of offender that has the specific profile. For youth offenders, it exists under Section 42M of the Act, except there is a provision that says that it's necessary for provincial directors to approve it. So that existed until 2013-2014, particularly in Montreal, and it was exceptionally effective. You took a youth who was at the beginning of their problems with justice, but it was a serious offense in that case, and the sentencing the custody happened with other offenders. And there were specialized units where there was custody just on the weekends. I can tell you that if you deprive a young person of their weekend, it's very effective. It is costly. You need to have educators who are involved in this program. And we saw in the several years following a decrease in criminality, and then those resources were cut. And then, of course, after the budget was cut, the offending upticked again. So this was an intensive rehabilitation program which should have been reactivated. It was not reactivated. So as soon as it started working, the funds were cut, but we need the funding again. So I think that it clearly shows how important this provision is, and what a bad decision it was to cut funding for it. It is a good opportunity now to rectify that and to make it mandatory for provinces to provide this type of custody for youth. That's what I was referring to. Thank you, Mr. Murias. You also discussed an opportunity that we should probably seize to redefine violent crime to include crimes committed using a firearm. Could you tell us more about what the effects of that would be, and why should we include firearms? To increase the sentence or to decrease it? Could you please elaborate? We have to understand that the Youth Criminal Justice Act operates on the principle under Section 39. So under Section 39, you have crimes with violence. Strangely, so a slap in the face, which is a very simple crime, does not necessarily automatically lead to a certain type of sentencing if there is a weapon involved. And it is negative for us to have to go through an exceptional clause. So I have provided a list of examples, and I think they are the most relevant ones. Excuse me, Mr. Murias. I understand, but we just don't have very much time. I want to make sure I'm understanding. What would the effect be if we were to add with a weapon in the definition of violent crime? What would happen? Would the sentences be more severe? What would be the effect? It would open the door to having crime with possession of a firearm lead automatically to a custody instead of having to go through a long and complex procedure. It must be done, and it is absolutely blatant that that there is this gap in the law. We absolutely have to rectify it. Thank you very much, Mr. Murias. Professor Sundberg, I was listening to you, and your testimony was very interesting. This is your first time at the committee, and it was very interesting to hear you. I have a question for you. Underlying all of this, what is the effect of minimal sentencing on the rate of crime? So, obviously, someone who's about to carry out a crime doesn't go to check the criminal code first to find out what their sentence could be. So, if we take away mandatory minimums or add them in, what would the effects be?
It's interesting, and I apologize that I can't respond in French. It's an interesting, when we think of deterrence, the research is quite sound that deterrence works because people are scared of getting caught. If sentencing were the solution, I think if on the extreme side in the state of Texas, where they have the death penalty, and it's quite swift, certain, and a significant outcome in Texas, we would see no homicide if it were in fact the issue of the outcome or the sentence. To that end, though, it's the fear of apprehension and the fear of being caught and then facing consequences, which is really that point that research would show ensures people experience that general deterrence. On a specific deterrence, however, when we think of an individual, then the sentence does play a role and their experience through the process. So if it's protracted,
Thank you. Mr. Fortin, sorry. I got this.
We just have a few seconds left.
We're gonna go a bit past one, but we'll get the entire second round in, so we'll do 5-minute rounds starting with Mr. Gill.
Good afternoon, and thanks to all the witnesses. My question to Mr. Copeland, extortion is a rising crisis at all levels, including my city of Brampton. Resident and business owners are scared. We know that most of these crimes are being committed by repeat violent offenders. Do you think this bill has the proper penalties to stop the extortion crime wave my community is experiencing?
No, thank you for the question. Ultimately, I would repeat what I've stated earlier, which is that the bill's focus remains too narrowly on bail, and they need to revisit it and modify sentencing provisions. I would like to see greater consideration for guidelines rather than principles and purposes. Now, this is a major undertaking, but it has been recommended before and was not adopted. This would remove some judicial discretion. I think other ways of doing it are by ensuring that deterrence and public safety principles are given priority among the other priorities and purposes that can be looked at in the criminal code for a much larger range of offenses. That would go some way to improving sentencing.
Would stronger sentence for repeat offenders be an effective way to combat the extortion crisis?
I think so, I'd be happy to build on the comments by Mr. Sunderland. He's quite right that deterrence is not just a factor of severity of sentence; it's predictability and swiftness of enforcement. And so, prosecution capacity, enforcement capacity are very important there. Court delays, but predictability at the judicial level, and we're talking about the criminal code here, is something under our control, under the government's control through this legislation. And so things like mandatory minimums, like moving to guidelines rather than principles, making sentencing outcomes more certain, also amending the Crown Prosecution Manual to create presumptions that certain serious, violent, and repeat offenses are prosecuted by indictment rather than summarily. These can go some way to getting there.
Next question is, you mentioned that our law and order problems are a lot bigger than bail. In Brampton, one of our issues is illegal firearms. Almost all of them are smuggled in from south of the border. Does this bill do anything to stop the flood of illegal firearms in Canadian cities?
No, not to my knowledge. And the government is focused on a buyback of legal firearms, which is not addressing the border security issue there. And they do have a border security bill with many admirable components, but ultimately our organized crime and foreign state actor risks are significant because we have many gaps in our law at present that make Canada a target for organized crime groups and foreign state actors like Russia, China, Iran, and proxies to operate in. And so I put forward a number of proposals earlier at committee today and in past writing that we look at exemptions to the Stinchcombe disclosure requirements that we know our allies are not sharing sensitive information because they must be disclosed through the hearings. So unlike our allies, we don't have the same type of capacity to ensure that is secure. And also case timelines. The Jordan principle has required that has set a range that is just not adequate for the complex, cross-border cases that involve a lot of intelligence and is resulting in a number of stays and withdrawals that we don't want to see.
Thank you. Conservatives have proposed Bill C-242, the Jail Not Bail Act, which includes a measure that would prevent convicted criminal from being a surety to another person. C-14 would not. I know that you have written about organized crime being one of the biggest problems in Canada. Should fellow gang members be allowed to advocate for the pretrial release of their associates?
Yeah, this does seem like an appropriate measure. I do think scrutiny is warranted to the extent that you don't want to.
I'm going to have to ask you to wrap up, Mr. Copeland, because we're very tight for time. So thank you.
Okay. Yeah, it does seem like a proposal that should be studied further and possibly included.
Mr. Housefather for 5 minutes.
Thank you. Thank you very much. I just wanted to, premièrement, merci tous les témoins.
First of all, thank you to all witnesses. Thank you, Mr. Muria, Mr. Copeland, and Mr. Sundberg.
I just wanted to start off from the principle that, again, this was a bill about bail reform, generally. It's called the Bail Reform and Sentencing, but it is a bill that is primarily about bail reform. It is a bill that happened after varied consultations with the provinces, with police, with a number of groups across the country. And we are at a point right now at this committee where we are looking at this bill and deciding on what amendments to put forward for Wednesday when we're going to be doing clause by clause in the bill. So it's wonderful to have a wide-ranging discussion on issues with respect to wide-ranging issues within the justice system. But I would remind the witnesses and my colleagues that they are beyond the scope of this bill. The bill cannot be amended to go beyond the scope of what the House of Commons passed already at second reading when it referred it to the committee. And so these discussions don't bear fruit if you're suggesting wide-ranging things that have nothing to do with what is actually in the bill. So Dr. Sundberg, can I start with you? Because first of all, let me say how impressed I was by your testimony, because like you, I'm a pragmatist and I'm concrete, right? This is a concrete bill, and we can only put forward what is the scope of the bill. And I really was very intrigued by what you said about the discrepancy between the immigration law and this bill. So could you, because I think you've presumed we've all received your document, but unless it's been translated, we don't get it. Can you talk to us a little bit in more detail about the amendment you proposed and what clause it would be, and just go over it in more detail so I have it in my head?
Point of order.
Mr. Lawton.
So I just would appreciate some direction from you, Chair. Our witnesses have been very forthright in their thoughts on what is in the bill and also what should have been in the bill. And I'm worried that Mr. Housefather's question is directing witnesses to basically say that they can't identify shortcomings that they believe should have been in the bill or amendments that they believe would improve the bill.
Thank you, Mr. Lawton. Okay, please answer the question.
I'll be very brief. I know that the time is of essence. My view of the bill, thinking of bail, and when I spoke to this committee in October, and some of the discussion around the issue or the incongruency between foreign nationals and the concerns that foreign nationals are engaged in the concerns, Mr. Gill, that you were speaking of with the extortion that we've seen this becoming quite an issue from coast to coast in this country. So my thought was, this is about bail. There's one aspect that I thought could be surgically adjusted, simply aligning the provisions of the Immigration and Refugee Protection Act, which Parliament has already, that bill since 2001 or 2002, I believe, by simply saying that any foreign national. So I'm not talking about permanent residents. I'm talking about those who are temporarily here, that if they are arrested and charged with an offense under 34, 35, 36, or 37, which are security grounds, human and international rights violations, serious criminality and organized crime, and if the offense that they were arrested and charged with, if they were convicted, would result in them becoming inadmissible to Canada under one of those four provisions, then it would, by having the reverse onus, provides a trigger point or a point of interjection where the police can now have some connection with the Canada Border Services Agency and with the Immigration Authority to ensure that we, in essence, are understanding that we have roughly 3 million foreign nationals in our country at a given time. If we think that only 0.5% of that 300 million or 3 million, that's 15,000 people. So if they're involved and we talk about the organized crime, we talk about how some of our system has been gamed because for 15 years we haven't had the rigor that I would like to see in our immigration program. Nevertheless, we do have laws that allow that to exist. If this one simple addition to this bill, specifically addressing foreign nationals, that eliminates one of the issues in my view. There's a lot of issues at play, and I was focusing on one fairly narrow aspect, but I do think it will have a specific impact when we think of issues of terrorism, when we think of the extortion that's occurring, when we think of the exploitation. And I do see it as a way of building trust in our system where those who came to Canada, who were fleeing countries because of these concerns, can know that the home that they now call Canada protects them from the threats that they were escaping from before. So I thought it was a surgical implant into the legislation, and there you go.
Thank you.
Oh, that's. Do I have any time left, Mr. Chair?
You have about 10 seconds. You have about 10 seconds.
I think it was a very helpful answer and a very helpful suggestion. Thank you very much.
Mr. Fortin for 2.5 minutes.
Merci, Monsieur le Président.
Thank you, Chair. I'll be quick. Mr. Sundberg. Earlier, Mr. Murias was telling us in his opening statements that recently the Supreme Court of Canada decided that the best way to deal with crime is through rehabilitation. I would like to hear you on that. In your opinion, is enough being done in terms of rehabilitation, or should more be done? And if so, what should be done to eliminate or reduce crime in our society?
Wonderful question. Thank you. My answer is no. We're not doing enough.
I always have wonderful questions. The problem is I don't have time.
I think when we reflecting on, and it's kept in my mind, the testimony of Regional Chief Terry TG from the Assembly of First Nations from British Columbia, when he was mentioning the unforeseen circumstances where we change law and how this could impact our Indigenous communities. That's where I see the lacking of resources. If we can have more rehabilitation programs, especially towards First Nations youth, we will have a significant impact and get greatest value out of this.
Et pour les jeunes délinquants?
And for youth offenders?
Young offenders especially. And I think when we look at young men in this country who end up in our criminal justice system, we need to do more. And the fact that we still see in 2026 such a high number of young male offenders, especially coming from many from Indigenous communities, it's an indication we need to do more.
Je sais plus combien de secondes, mais très peu. Vous avez...
I only have a few seconds left. So you said that the death penalty has an impact on reducing crime. I just want to make sure I'm understanding you. So having 2 or 3 years of minimum penalty, what effect would that have?
I actually was saying that the death penalty in Texas is an example of where it doesn't fit. But with if we can truly focus and put resources into young offenders, we are saving money in the long run. And if we target it towards the demographics that are most impacted by our criminal justice system and the lacking of resources, it would be from our young Indigenous First Nations youth across this country. And we by helping them, we're helping not just those communities, but all of Canada. And we're taking the stresses off our system in a manner that is benefiting those who need it and those who unfortunately are most pronounced in our justice system, young Indigenous men. And by giving the resources and increasing the resources, we will see returns tenfold, both with the vibrance and the benefits to those communities where those young men come from. And
thank you.
Merci.
We need to do something.
Thank you, Mr. Fortin. Mr. Lawton for 5 minutes.
Start with you, Dr. Sundberg. I appreciated your comments about how grateful you were that the Liberals had agreed to set aside the very divisive Bill C9 so that we could finally focus on bail reform. My Conservative colleagues and I had tried to do that dozens of times in the fall, and I'm grateful last week our Liberal friends finally agreed. So I'm glad to be here. Let me ask you about the comments you made previously where you said we have a watered-down criminal justice system that is focused more on making excuses for why people committed the bad things they did and how to reintegrate them quickly into society. This is, I think, a very important point, and we have heard from victims where there is no second chance. There is no application of legal theory. They have lost loved ones that they will never get back. The system cannot afford to get these things wrong. So beyond bail and sentencing, is there something we're missing in this discussion that needs to be front and center?
Data, communication, thinking of the investment in ensuring that law enforcement professionals across this country have access and information that they can share with one another in a timely manner, that researchers like myself have access to data so that we can provide good insight and advice, and for the media so that they can inform Canadians of what's happening. We have such a stranglehold on our data around crime that it's such a hindrance for our ability, not just for the police to do their job, but for all of us. And I think if there is one touch point where I think that our Parliament could improve is taking a serious look at how we manage the information with regards to offenders, the decisions that are being made in our criminal justice system, and making data with regards to our criminal justice system much more available and transparent, as we see in the other Five Eyes. We are far behind in our release of data to those who need it.
Thank you.
It's the people's data.
On Bill C-14, the Liberals have offered a clarification of the principle of restraint, which has become one of the biggest issues identified by law enforcement as having a large effect in why bail has become so easy. And even Ari Goldkind, who was referenced earlier by my colleague Mr. Chang, he as a defense lawyer said the principle of restraint has made it easier for him to get his clients off on bail. The problem we have here is that the government is saying right now that something different is being said by this than judges are reading into it. And I'm hoping you can help adjudicate this dispute, because law enforcement officials, when they come to us, are saying you can draw a direct line between Bill C-75, which codified the principle of restraint, and a lot of the decisions we now see that have really not made public safety the primary consideration. So who's right here?
Wow. I think restraint is an important consideration, but it must be applied in a structured, consistent, and thoughtful manner. And I believe that some of the frustrations we see with a lot of Canadians is where it falls short. Again, I do believe it's important to point out that we have the majority of those who do go before a court on a charge will end up in a remand center, and that the issue, and I think Mr. Copeland did an excellent job in addressing this, is where we think of when it comes down to when we're doing the omnibus collection of charges, that often happens where a lot of information is lost, or the information that the police in one jurisdiction might want to know and rely on. It's the guidelines. I think Mr. Copeland's idea for focusing on developing guidelines and working on that, and the idea of the other witness who brought up the idea of having ministers' meetings with regards is also wise.
Thank you.
I just feel that we haven't been consistent, and we need to get that consistency, and that's what I feel Parliament has responsibility to do.
Thank you, Dr. Sundberg. I'll turn to you, Mr. Copeland. I have time for one further question here. We had heard from Minister Fraser last week that the reason Bill C-14 was not the Liberal government's first justice bill was because they wanted to get it right. But you've identified that this only tackles a very small subset of what you think is a broader set of challenges here. So how much of an impact do you think C-14 will make in light of your previous testimony today?
Yeah, thank you for the question. What I'd say is I was involved with the development of Bill C-48, the provincial level. The provinces led to, the federal government to adopt it at the time. It was focused just on bail because it was
Thank you, Mr. Copeland. I'm going to have to stop you there. In fact, we're not short on time. We're out of time. And in fact, we're well over past 1 o'clock. So I'm going to stop the meeting here. Just remind everybody we're starting at 3:30 on Wednesday, not 4:30. I'm told by our clerk that a number of amendments have been submitted. If there's any stragglers, get them in real quick, please. And I'll see everybody on Wednesday at 3:30. Meeting.
Okay, so we're going to call it here, and I'll see you guys for question period. Hold on, let's see what he's saying last second.
To all of us is very helpful. Meeting adjourned.
He was just thanking the witnesses. Okay, I've put the link in chat. I'll put it in there again. There's question period, and I'll see you guys in about 50 minutes.